Today's courtroom clash features a familiar face, Albert Hicks, a sovereign citizen who previously managed to dominate the conversation against a much more patient judge. But today's hearing is a completely different environment. This time he's facing Judge Perkins, a judge known for keeping tight control of the courtroom and shutting down arguments that wander outside actual law. And right from the start, the tone of this hearing signals that things won't unfold the way Hicks expects. What makes this case fascinating is the contrast. A defendant relying on constitutional buzzwords and sovereign citizen logic versus a judge focused strictly on procedure, court rules, and moving the case forward efficiently. The big question becomes whether Hicks can adapt to a courtroom where the judge, not the defendant, controls the pace of the conversation.
This is the city of Detroit versus Albert Hicks Jr. Case numbers SP 1442547, counts 1, 2, and 3. SP 1427651.
Okay.
And it looks like the rest of this stuff. Then I have SP 1500872. And it looks like the rest of this stuff he's already entered a plea into all this stuff.
No, sir. No plea.
Well, that's not what it says here, sir.
I represent myself. I couldn't enter the plea. I never plea. You can check my record for plea.
Oh, maybe I found you guilty then. Yeah.
No, I haven't been. Matter of fact, I came inside there personally a week or so ago. And the young lady, the security officer, came out and said that I'm supposed to report today.
No.
One of the most important decisions in any criminal or civil case happens right here, whether to accept legal representation. Hicks chooses to represent himself, which is absolutely his right under the law. But that decision carries serious consequences. Lawyers understand procedural rules, evidentiary standards, and how to structure legal arguments in ways courts will actually consider. When someone represents themselves, the court assumes they are responsible for following the same rules as a trained attorney. Judges can sometimes offer basic guidance, but they cannot act as a personal legal coach for one side of the case. That's why judges often encourage defendants to accept counsel. It dramatically improves their chances of presenting arguments effectively within the legal system.
This is on some old stuff. All right.
I never entered the plea.
So do you not want the representation of counsel?
No, thank you.
Okay. There you go, Mr. Take. That's your first break of the day, Mr. Soroki. You know what I mean?
Judge, I know how to deal with everybody. So I said I know how to deal with everybody, any type of client.
Yeah, I know, but he doesn't want
right,
it. So
I understand.
We can't force it on him.
No, I understand.
Yeah. So you can
take it as a plus.
So Mr. Lee, today is the date and time set for a show cause. As for purposes of arraignment, sir. We'll do it like this. I'll enter a not guilty.
Are you talking to Mr. Hicks or Mr. Lee?
Pardon me?
Yes, you should be able to find the first one.
Are you talking to Mr. Hicks or Mr. Lee?
Mr. Hicks, I'm sorry.
Yep, you should be down in area code 929.
Mr. Hicks, for purposes of arraignment, I'm going to enter a not guilty plea on your behalf and give you a $0 bond, all right?
I object, Your Honor. That would be practicing in front of the bench.
It's the same process.
Say that again.
I object. That would be practicing from the bench, practicing law from the bench. You will have to recluse yourself if you hold on to that.
All right. Well, I deny your motion. So go ahead. How do you want to proceed?
I would like for everything to be dismissed, if it pleases the court.
Denied. What basis?
You
what
haven't
basis?
even let me tell my grounds.
All right, basis. Give it to me.
Now we hear Hicks introduce a constitutional argument involving something called a bill of attainder. Historically, a bill of attainder refers to a law passed by a legislature that punishes someone without a trial. The Constitution specifically prohibits those kinds of laws. However, applying that concept to a routine traffic citation is a huge legal stretch. Traffic tickets and similar citations are part of the normal judicial process. They're not laws targeting a specific individual without trial. Courts across the country have repeatedly rejected attempts to apply the Bill of Attainder Clause to standard criminal or civil infractions. This moment highlights something common in sovereign citizen arguments, using real legal terminology, but applying it in contexts where courts have already ruled that it doesn't apply.
For one, a ticket is a bill of attainder. Article 1, Section 9, Clause 3 of the Constitution of the United States, no bill of attainder or ex post facto law shall be passed. You can have a written assistance
All right, let me
to
stop.
equity that transmitted into law penalties.
Let me stop you right there. We have, first of all, we have a problem with the transmission. You're breaking up really, really, really bad, and we can't get that on the, turn your video
I
off.
understand.
Maybe turn your video off, that will help. Let's see. All right,
Is it
try
better?
it now. Try it now, let's see. Go ahead.
Did you hear what I said?
Yeah, I'm listening.
Okay. Article 1, Section 9, Clause 3 of the Constitution of the United States. No bill of attainder or ex post facto law shall be passed. You cannot have a writ of assistance that has civil equity that transmits into law. Number 2, there is no sworn statement from an injured party. Number 3, the officer did not even sign the ticket. That's under law penalty of perjury. I'm asking that all of these be dismissed.
All right, I'm going to deny that motion. All right, how else do you want to proceed?
That's your declaratory judgment?
I'm going to deny the motion. I denied the motion.
Okay, let's go to court.
Trial?
It don't matter, because I don't understand how y'all run y'all system. Y'all practice against the law.
Here Hicks introduces another common sovereign citizen concept, the idea that he is operating strictly under common law rather than statutory law. In reality, the modern legal system combines both. Statutes, laws passed by legislatures, work alongside common law principles developed through court decisions over time. You can't simply opt out of statutory law by declaring yourself a common law free man. Courts have jurisdiction over cases based on geography and the laws enacted within that jurisdiction. That's why Judge Perkins quickly moves past the argument and focuses on the next procedural step, setting a trial date where actual evidence and applicable law can be examined.
I'm a common law.
Well, read the court rules, and you'll learn a little something.
The court rules go against the law. Y'all practice against the law, against the Constitution. I'm all common law.
All right. Well, we're beyond that.
Okay.
All right.
So you say. So are you going to prosecute this, or somebody else going to prosecute it?
Stop. Let's not keep going. All right. You want a trial date, or not?
It's up to y'all. Remember, y'all make all the rules.
Trial date. You want to? Let's give him a jury trial date.
Jury trial.
Yeah.
How long do I have to turn in my briefs?
I'll give you some dates in a second.
Okay. Scamming. with a smile on your face. If it pleases the court, what jurisdiction are you charging me on?
I asked the question, sir.
I just said if it pleases the court.
I know, and I'm telling you, I asked the questions. I appreciate your respect for the court, but I asked the questions. I told you to read the court rules.
March the 5th. Let me check and see.
The court rules. What jurisdiction are you trying to charge me on?
Is March the 5th a good date for you, sir?
No.
Okay.
June the 11th is going to be the jury trial date.
June the 11th?
June the 11th. So let's put your final pretrial date will be, let's see, put that a day before. That way, that'll be the date we'll argue motions on June the 10th. May the 24th will be your motion, and now May the 24th, and the city will have 7 days to respond. So the response to the motion will be due by May the 31st.
I appreciate you, Your Honor.
All right, have a very good day, sir. Best of luck to you.
I just did. Thank you.
Good morning. You have a final pretrial set for June the 10th, and you have a trial date. You have a final pretrial set for June the 10th, and a jury trial date set for the same day. Okay, that's not correct.
Yeah, you did.
Hold on one second. Let's get the date straight.
I'm not here for that.
What are you here for, sir?
The slip says for Jonathan Reeves.
Jonathan Reeves.
Yes.
I don't know anything about a Jonathan Reeves. Let's see. Maybe. I don't know anything about a Jonathan Reeves.
Well, I motion for this case. Man.
Are you Mr. Hicks? Are you Albert Hicks?
Yes, I am.
Okay, so we're going to get you your dates, and that Jonathan Reeves.
I already have my dates. I talked to you last week, remember?
I think it's correct.
I have June the 10th and June the 11th.
Very well. Okay, we'll see you back on those dates, sir.
But this matter right here with this Jonathan Reeves.
Well, what does Jonathan Reeves have to do with you?
That's what I'm here for court for today. I'm making a personal special appearance for this.
Okay, I don't know. Who is Jonathan Reeves? Do you know who that is? What does it say on that? Because it sounds like it may be Jonathan Reeves may have stayed at that address at some point and left. I don't know what that's all about.
This moment brings up an important concept in the court system called judicial economy. Courts often consolidate related matters or schedule hearings together to save time and resources for everyone involved. From the court's perspective, handling multiple related issues in one hearing reduces repeated appearances, duplicated testimony, and unnecessary delays. Hicks views this decision as a violation of his rights, but from a procedural standpoint, it's actually a common practice in busy court systems. Judges frequently manage their dockets this way to keep cases moving efficiently, while still preserving the defendant's ability to file motions or raise objections through proper legal channels.
I'm asking that this case be dismissed. The case is SP SP15008721.
SP15008721. Okay, that's not
Okay.
Jonathan. Okay, Jonathan Reeves is the officer that apparently wrote the ticket.
And where?
And that's scheduled for the final pretrial on, I see where he's here today. It says scheduled for pretrial today. But that's all gonna be handled on the 11th of, Jonathan Reeves is supposed to be here on the 11th of June, on the day
I
of
was
trial.
not notified. 11th of June.
Yeah.
How is he going to be here on the 11th of June? And I have Spidell on the 11th of June.
You have a couple of different officers, obviously.
Jonathan Reeves and Spidell has nothing to do with each other.
Well, we're just consolidating. We're having all of them here.
Why would you do that against my will? Why would you just do that?
I'm doing it because of the judicial economy, sir. So
I'm challenging that one.
Okay, then write a motion, and we'll rule on it. But it's all in the same. We're all going to do it on the same day.
You didn't ask me that.
I'm in charge. I get to do shit you don't get to do. It's part of the black roll, okay?
I don't have to ask.
You didn't ask me that. You just arbitrarily did it. That's not right. That goes against my rights.
All right. Well, you can put it in a motion, sir.
Well, the whole thing is, I don't know what y'all doing down there, but you are totally infringing on my rights.
Okay, well, file a motion, sir. That's how you speak to the
Why
court.
would I have to file a motion when you infringed on my rights? And I'm saying it right here, right now.
That's what the court rules are. You gotta follow.
No, it's not. Then show me those rules. Let me see those rules. Send those rules to me.
I don't have to show you anything. That's all public
Oh,
information.
you're acting tough now? You're acting tough now? Behind the bench?
Mr. Hicks.
Let's
not go there, all right?
My honor, please. I'm bringing up valid litigation for this. I don't know what y'all doing. Y'all can't do anything without my permission. I'm not a ward of the state.
Mr. Hicks.
I'm an unfranchised common law free man.
Mr. Hicks. All I ask you to do is you can file a motion. You can put all of that stuff in the motion.
Yeah, so y'all, so you can come back and say motion denied, right? Like you did last time.
Well, if it's not, that's my discretion. If I don't feel that if it doesn't meet the criteria of the law, then that's what my
What jurisdiction are we?
I'm not going to answer this question, sir.
Oh, you're not going to answer the questions? Then I would like to know your status.
You don't ask the questions. I ask the questions. That's how.
Oh, you're going to play like that. What is your status? I am a common law free man. What is your status?
Listen, Mr. Hicks. Mr. Hicks, I'm about to put you out the room, and I'm going to do that so I don't have to find you in contempt. I don't want to do that. Okay. I'm giving you your opportunity to speak to the court through motions. You have your motion date already set. You can put all of that stuff in the motion, okay? And
why wasn't I notified about this case, this particular?
You are notified. You have it here. You have it there. That's why you zoomed in. All right, Mr. Hicks. All right, now I'm going to give you one last chance to speak, sir. Go ahead and well, before the other litigants come on.
And Your Honor, we're not on the record with Mr. Hicks.
No, we're not on the record.
We should be on the record with Mr. Hicks.
We're not, you don't have a court date today, sir.
I have a court date. I have the paper right in my hand. I have the paper right here in my hand.
In that case number, I told you your court date is, you have motion dates for that. You have,
You just told me, you just told me that. What did I have a court date today for? Why did I waste my time to come here just to hear this?
Well, I mean, sometimes that happens. I mean, if you feel that you're wasting your time, then
It's the fault of mine. It's the fault of 36th District. Y'all asked me to come to Zoom today.
From what I see here, sir, it's
It has pre-trial on here. Wednesday, February 7th, 2024, 9:35 a.m.
all right. Let's do this. Let's call the case.
Zoom hearing meeting.
Hold on a
For
second.
John.
Let's call the case. Let's call the case. This is the city of Detroit versus Albert Hicks Jr. Case number.
By this point in the hearing, you can see a recurring pattern. Hicks attempts to challenge the legitimacy of the court's procedures, while the judge repeatedly directs him back to the proper legal process. File motions, follow court rules, and present arguments at the correct stage of the case. Courtrooms aren't designed for open-ended debates about the entire legal system. They operate through structured steps: motions, hearings, pretrials, and trials. When someone tries to bypass those steps by arguing everything at once, judges typically respond the way Judge Perkins does here, by redirecting the discussion back into the established framework of the court.
SP 15008721. State your name for the record, please, Mr. Hicks.
Albert Hicks.
Today is the date and time we'll call it set for a pre-trial date. I see here.
This is supposed to be the trial. Excuse me, Your Honor. This is supposed to be the trial date.
It's supposed to be the pre-trial date, correct?
Absolutely.
Okay. Mr. Hicks, based on the nature of the allegation, the city's not going to give you an offer for this case. They want to see and speak with the officer, one being the gentleman you referred to off the record, Jonathan Rivas, and then there's another officer, Daniel Colgrove. Either one of those officers, they're both going to be summoned. I don't know what their testimony will be, but
I motion to dismiss.
Let me finish, and I'll let you speak. All right?
Yelling at me now?
Yes.
Is that constitutional?
All right.
Over. Okay.
So let me finish, and I'll let you speak. If you're not going to do it that way, you're either going to get out the room, or you're going to be in. I'm going to lock you up. All right, so today is the date and time set for a pre-trial. And this pre-trial, the officer is not required to be here for a pre-trial. The pre-trial date is set in order for you to get an offer to either settle up the case, or in this case, we're setting a trial date. You have dates already set. The date motion due is going to be on May the 24th, 2024. The response to that motion, if the city chooses to respond, is going to be on May 31st, 2024. Your next court date that you need to be present is going to be on June 10th, 2024 at 8:35, with the jury trial set the next day on June 11th, 2024 at 9:35. Okay? Now,
by the end of these two hearings, the situation becomes pretty clear. Albert Hicks' attempt to challenge the court's authority, using a combination of constitutional references, sovereign citizen ideology, and procedural objections. But Judge Perkins keeps the focus firmly on the legal process, entering a not guilty plea, setting motion deadlines, scheduling pretrial hearings, and preparing the case for trial. Instead of getting pulled into long debates over legal philosophy, the judge repeatedly points Hicks toward the correct way to raise arguments, through formal motions and proper courtroom procedure. Whether Hicks ultimately succeeds with any of those arguments will depend on what evidence and legal reasoning he presents when the case moves forward. If you found this case as shocking as we did, make sure to hit that like button. Share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.
I'll let you speak, and we're going to end it.
Is all of this on record?
This is all on record.
Is all of this on record?
Yes.
Okay, please send the information to my home, please.